All right, next thing we're going to talk about some emerging claims, and for this, we're going to start off with Deanna Kawada. She's going to talk a little bit about some of the things we have in our agenda. And the first is the amalgamation theory. If you do construction defect work in South Carolina, this is something that if you've been involved with it, you don't like.
Thank you, Roy. I am Diana Coada, and I'm originally from Romania. I've been an associate with Rogers and Townsend and Thomas since '08, but I'm also known, after being over 13 years in South Carolina, as the honor from Seneca. So how many of you have heard of amalgamation before? Nobody. Oh, 2 people. Amalgamation is a theory that is very similar to another concept which is called the piercing of the corporate veil. The piercing of the corporate veil involves the situation when you have a corporation that is being dominated or controlled by one or more officers or owners. And normally in that situation, the corporation was set up for an improper purpose or to perpetrate fraud. The piercing of the corporate veil allows the court to disregard the corporate form and allow plaintiffs to reach the assets of the individual owners and officers. Amalgamation is sort of the same thing, except that it is defined as the unity of one or more entities whereby one merges into the other. And unlike the piercing of the corporate veil, amalgamation does not require showing of dominance and does not require showing of an improper motive. I'm just going to give it an example. And first of all, before I go on, amalgamation has not been recognized or applied in North Carolina, however, has been applied in South Carolina, which, like Roy said is quite scary. The situation that was involved in the cases that are referenced in your materials in South Carolina was a developer builds a property. Turns it over to the property owner association. The owners turn around and sue the developer for, among others, a construction defect. While building the property to protect itself or for other possibly proper reason, the developer creates a management corporation, a marketing corporation, a selling corporation that is going to sell, let's say, the condominiums or timeshare units and generate revenues that way. Now, when providing insurance coverage to the management company or the marketing company, you'd never think that the risk involved would also involve claims against the general contractor or development company. Amalgamation is the tool that allows the courts to hold that there was such an amalgamation of corporate interests and activities that it is all one and the same, meaning the marketing company or the management company that is being set will be held liable for the acts of the general contractor and vice versa. So amalgamation is quite dangerous in the very sense that it just opens up the door to liability all over all the related entities that the developer created for that same exact purpose of avoiding liability. There is not a clear test as to what factors come into play in deciding whether amalgamation exists and whether all the entities will be treated as one and the same. However, some of the factors are having corporations that have same or substantially the same owners, same or substantially same officers, using the same telephone, using the same location, having the same email address. One of the more important factors is also having the separate corporations telling the public or holding themselves out as a common entity. And note that in this situation, there's no requirement that plaintiff show that plaintiff relied to its detriment when relying on the, let's say in my example, the general contractor's example, that all his companies were one common company. The good news is that North Carolina does not, like I said, does not require or recognize amalgamation. In North Carolina, in order to pierce the corporate veil or to disregard the corporate form, the plaintiff has to show that the corporation or its related entities were created for an improper purpose or to perpetrate fraud. And in 2008, the Supreme Court of North Carolina said that proceeding beyond the corporate form is a very strong step. Like lightning is severe and rare. So it appears that the risk of having the corporate form disregarded in North Carolina is much lower than in South Carolina. Another emerging claim that relates to construction defects and environmental claims is the component manufacturing liability. And what this means is having a plaintiff who sues the manufacturer of a component part that in itself is not defective, but that is used in a larger product that the plaintiff alleges is defective. For example, a manufacturer may make a window. The window, there's no defect to it. However, if the window is used improperly in a certain building with a certain design, a certain cladding, the manufacturer of the component part might face liability. The causes of action associated with the component part product liability are failure to warn, negligence in coordinating with the architect or engineer who's going to place the product in the building, improper. Go ahead.
So you're saying in that situation, we'll use your window manufacturer. You have a window manufacturer that supplies windows to Lowe's, Home Depots, or whatever. GC, home builder, comes and grabs one of those windows, puts it in, installs it improperly, or is not using it the right way. That the window manufacturer is going to have to be advised of each and every window and how it's being applied or where it's going in, and ask about that to avoid this type of litigation?
Well, typically, you have the defense of the sophisticated user. So in the case of the Lowe's and Home Depot, you might have the argument that those are sophisticated users who should have known that using that particular window in this kind of setup.
I don't know, walk through Home Depot and those guys around
But yeah.
I'm sure that argument would fly.
Yeah, no, but you do have, as a manufacturer, to at least set forth the uses that are proper. You're not expected to set forth every single improper use of the product.
When they're sending their windows out in that scenario to different places, they probably should revisit the literature that they're applying with that to try and shore that area up.
That's right. I mean, you have to at least provide what proper, and of course, you know, we're dealing with litigation here, so that's a really vague concept. Do the best you can to delineate all the proper uses for the particular component part you're putting on the market. Another cause of action at the end is warranty claims. For example, you can properly disclaim some uses. And that's the last example. The manufacturer can identify improper uses and set those forth as well. And I do have to know that the component manufacturer doesn't mean that there is a duty to try to guess every single possible improper use, and you don't have a duty as a manufacturer just because there might be a conceivable go ahead.
But the key to that is not being brought into litigation, incurring all these litigation costs when you don't have to incur them, nor should you be incurring them, and trying to prevent being brought into litigation up front by doing something.
That's right. You do the best you can, but I was going to go into the standard. That doesn't mean that it's just a blanket duty that applies to everybody, that you have to, that it, you know, there's a duty just because the product might conceivably cause injury. The plaintiff has to show that the component part was dangerous, that the manufacturer knew or should have known that the component part was dangerous, that the danger was not obvious to the consumer, and then in addition to that, that it was a danger that was not readily discoverable by putting it to an expected and foreseeable use. So that's the standard. what are the defenses? One of the defenses to this type of claims are the economic loss doctrine, about which Brian talked earlier, and the learned intermediary or the sophisticated user, and that's the situation where you have an engineer or architect who goes and buys a window that he knows better not to put in that type of setup and does so.